Prior to July this year, family violence was being dealt with either as an exceptional circumstance or sometimes as part of homelessness as a special circumstance. Since July this year, family violence is now recognised as a special circumstance in itself. However, this does not take into account victim survivors who end up with fines as the registered operator where the perpetrator of violence was the driver of the vehicle. And the Infringements Court currently treats that situation under exceptional circumstances, and we know the problems that come with going through exceptionals. Even if your client does get through specials, she needs to plead guilty to the offences, and that has its own problems. So the Family Violence Royal Commission examined this issue and recognised the problem, particularly of perpetrator incurred fines, and recommended legislative change to enable a victim to declare that it's unsafe for her to nominate the driver. So the Department of Justice developed an initial proposed scheme to respond to this recommendation. Unfortunately, the original scheme would have created significant problems for safety and accessibility for victims. That scheme would have required victims to identify perpetrators. It would have required the Magistrates Court to determine most of the matters. And it even contemplated transferring penalties to perpetrators from victims, including by joining perpetrators to victims' proceedings in the Magistrates Court. So I'm sure we can all be thankful that that's not the scheme that we've ended up with. It's great that the department was receptive to feedback about the problems with the proposed scheme, and we think that they've settled on something that will be much safer and more accessible for victims of family violence. In terms of eligibility, drink and drug driving and excessive speeding offences will not be eligible to be dealt with under the scheme. That's the same as specials and exceptionals. You won't be able to apply to the scheme if you've already applied for enforcement review on the grounds of family violence, but it will be preferable anyway to apply to this scheme first. And importantly, an application must be made before the 7-day notice expires. We've talked about that today. Before an attachment of earnings or debt order is made, before a vehicle is being seized, before a land charge has been recorded. And we've heard today that under fines reform, sanctions are going to be imposed with a lot more frequency. So it's going to be critical for us to try and engage our clients as early in the process as possible. And one of the good things about the scheme is that you can apply with respect to infringements whether they have been registered with Fines Victoria or not. So that means you can also apply when fines are still at the enforcement agency stage. The test requires that the applicant is a victim of family violence and that the family violence substantially contributed to an inability to control the conduct constituting the offence, or in the case of offences, so that was in the case of offences committed by the victim, or in the case of offences committed by the perpetrator, that the victim was the registered operator but not the driver of the vehicle, and the family violence substantially contributed to an inability to nominate the driver. So you'll note that the nexus requirement is not as high as special circ, so substantially contributed rather than resulted in. So what happens if the application is granted? So where the applicant did commit the infringement offences, registration of the fines will be cancelled and enforcement action will be ceased. Any additional fees will be waived, and the director will direct enforcement agencies to withdraw the fines. So this is essentially what's fantastic about this scheme. If the application is granted, the fines are withdrawn. That includes the demerits. The demerit points are also withdrawn, and that's the end of the matter, no requirement to attend court. So that's what's really positive and really different from special circumstances. So if the application is granted and the applicant did not commit the offences, there's a slightly different process. The applicant will be given an option to ask for further time to nominate the driver, but that's optional. If she requests extra time to nominate, enforcement will be suspended for up to 6 months. And if she does not nominate within that time, then the fines will be cancelled and withdrawn in the ordinary way as if she had committed the offences. Now, obviously, the deferral of nomination idea is based on an assumption that it may become safer for the victim to nominate down the track. We know from our experience that family violence is rarely going to dissipate in that kind of short period, but on the positive side, the legislation doesn't pressure victims to nominate. If your client wants to, she can just not make that request for extra time and just get the matters finalised immediately. And again, there'll be no need to attend court and the demerit points will be withdrawn. What remains to be seen, I guess, is commonly for our clients, we'll see a mix of perpetrator-incurred fines and victim-incurred fines, and often our client doesn't really know which are which. So it remains to be seen how the director will deal with applications where the applicant isn't sure who committed the offences. The director will have the power to request further information from applicants, so they may do that, but it still remains an open question how they're going to resolve this issue. So there are no evidentiary requirements set out in the legislation. I've been told that the department understands that not every victim will have an intervention order or will have engaged with a family violence service, and they don't want that to exclude someone from accessing the scheme. So at this stage, what will meet the threshold is a bit unclear, and it may be that some guidance is published down the track. From my perspective, I think it's positive not to have a minimum defined threshold. It promotes flexibility for victims. What we can anticipate as being necessary evidence will be either a stat dec or a support letter that establishes the family violence and the nexus with the offending or the inability to nominate. A range of other documents might be relevant as well, like VOCAT applications and findings, police reports, safety notices, intervention orders, maybe stat decs from other family members or other people. So it's likely that we're going to be assisting a lot of our clients to draft stat decs, setting out the history of their family violence and the nexus to the offending or the nomination. There is a concerning aspect of the scheme that the sector will need to monitor closely to see how this actually operates. The director will have the power to refer matters back to enforcement agencies where he considers these circumstances and considers it to be appropriate. It's concerning because, as you can see, some of the factors include that there are a large number of offences. We know that's very common for family violence related fines, or where victims need to make multiple applications to the scheme over a number of years to deal with their fines, and we know that's also very common. So that's concerning. What happens when the director refers the matters back to the agencies is that the agencies have a number of options, and one of them is to prosecute the offences that are referred back to them, and that's obviously concerning. It has the potential to seriously undermine the scheme and deter applications to the scheme. So we'll really need to keep an eye on how this operates, and hopefully the director won't be referring too many matters back to enforcement agencies. As we've heard, the new section 160, it sets out the powers at penalty enforcement warrant hearings. So after a warrant has been executed, a person has been arrested and bailed to court. So in addition to the current grounds for discharge, which you'll know are that the person has special circumstances or a mental illness or intellectual impairment, or that imprisonment would be excessive, disproportionate or unduly harsh, there'll be this new family violence ground, which is expressed in the form that the person in default is a victim of family violence that substantially contributed to the person being unable to control the conduct which constituted the offending. So you'll notice that the provision doesn't explicitly take account of perpetrator incurred fines, but that situation will likely fit under the power of disproportionate, excessive or unduly harsh, hopefully. So overall, the scheme introduces some strong provisions to enable victims of family violence to deal with their fines. We think it's really positive, and We're grateful for the department's work on the scheme and engagement with our sector and with the family violence sector. There are a number of aspects of the scheme that we'll need to keep an eye on. There will be a review of the scheme after 2 years, so we hope that there'll be some scope for recommendations and amendments at that stage. Thanks.